Thank you very much. There's an old theatre rule that if the cast outnumbers the audience, then the show doesn't go on. I think we just about clear that hurdle. Anyway, we are delighted to be the meat in the Adrian Bell sandwich this afternoon. My panelists need no introduction because you've, I think, seen them both before over the course of the last couple of days. So I'm delighted to have with me Amir and Nabil, and we're going to talk about dispute avoidance and dispute resolution. As we all know, construction tends to be highly adversarial. Been lots of attempts to improve that over many, many years, and some forms of procurement, for example, partnering and alliancing, are intended to reduce the incidence of disputes. And the same is true for some forms of contract, I think. You know, for example, if you look at the NEC forms, they approach entitlements in quite a mechanistic manner, and perhaps those leave less scope for debate. But today we're focusing not on procurement methods or forms of contract generally, but on dispute avoidance and dispute resolution mechanisms themselves. So let's start at the beginning. Let's start with some terminology. And I know we touched on this yesterday, but what is a dispute? Or rather, at what point in the usual back and forth between parties to a construction contract does a disagreement or a controversy turn into a dispute? Nabil, do you want to help us with that?
Yeah, sure. Good afternoon again. Without laboring the point too much, I think we can sort of quickly go through that issue. A very quick distinguishing issue between a notice, a claim, and a dispute. A notice is just a simple, as it says, notification from one party to the other that there is something that they would like to resolve, or they believe there's an entitlement they have under the contract they want to notify the other party of. A claim is the next step in that, where there is a certain protocol by which they then identify their contractual entitlement and quantify it for time and cost, and that's then submitted to the engineer or any other contract administrator on the project and the employer, and then it's there to be determined or agreed. And at the point where often there is there's no agreement as to whether the entitlement exists or whether the claimed amount of days or cost is agreed, you enter into what's called a dispute. FIDIC actually, I believe, now have that as a defined term. I won't go into what they say, but it's simply a case where either party agrees or the engineer doesn't agree with a claim made by either the contractor or the employer, and hence a dispute is crystallized.
Thanks, Nabil. So, I mean, the way I think about this is that claims, if you like, are simply part of the normal contract mechanism for adjusting the contract price, adjusting the period, and there's nothing wrong with having claims. You expect them on every job. It's part of how these sophisticated contracts regulate what contractors' entitlements are. Disputes, on the other hand, are where they've gone a little bit beyond that, and you've got potentially a problem of some kind. So I'm a dispute lawyer. I love a good scrap. But some of my clients tell me that they are lovers, not fighters. And so they are keenly interested in dispute avoidance techniques. So Nabil, other than depriving me of gainful employment, are there any downsides to dispute avoidance?
I'm struggling to think there is. The avoidance issue, as we had a quick touch upon earlier, is there to not give Tony work, but it's a simple fact that disputes and their resolution through the means of arbitration, mediation, litigation, or any other means of resolution is an expensive process. It's time-consuming. It has costs that are not always recognized, and to avoid that and to be able to try to resolve your disputes without going to that horrendous amount of time and money is something that I think is tantamount to a good or a successful construction project. So I'm struggling, but I'm sure Tony will correct me to sort of point to any significant issues that avoidance is not a good thing. So I would say that avoidance and the dispute avoidance mechanisms that are there are beneficial to the overall running of that project.
So perhaps we'll come back to that when we come on to talk about the FIDIC form in particular. Anna, perhaps you could take this on. What do you see as the sort of the necessary or useful prerequisites to dispute avoidance working well? What means that you can adopt dispute avoidance? What makes it successful? What makes it work?
Okay, to add of what Nabil said regarding dispute avoidance, practically saying it starts from square zero, which is drafting the contract. If you don't know how to draft the contract and you draft like the dispute resolution clause as a mess, and you don't know really how to draft it or to draft some messy contract, so you already created a spark for 10,000 disputes, okay, the contract. So this is number one. Number two, how to avoid disputes. If you have a variation, let us talk about the mechanism of the variation. I can, if I am the engineer, I can instruct a variation and I can ask the contractor to submit a proposal, right? If I have the spare of the time, I will ask the contractor, give me the proposal of the variation. So from now onward, before doing anything or spending any money or any time, we're already in agreement for the time, EOT, cost, new rate, build-up rate, everything is in place. Okay, so where is the dispute in the variation? Zero. Okay, rather than Tony gave me the instruction, Mr. Contractor, please proceed with this variation and we'll agree later. I am obliged to proceed. This is number two. Also, we have to have a good faith, which is a very iconic clause in the civil law jurisdictions, like Article, I think, 246 in UAE civil law jurisdiction and other civil law jurisdictions. Last but not least, Tony, is the time frames. We have to add the particular conditions. If it's not in the general conditions of contract, some time frames like the ones created in the 2017 FIDIC Rainbow Suite, Nabil. So there is a time frame. What is one of the most important spark dispute in the construction field? It's the program. We commenced today, okay, but we don't have an approved program 4 months later. Oh my God, so how we are working, how we are monitoring the progress, if there's a claim, if there is anything, how we deal with it, because the engineer sometimes he's afraid to give that consent or no objection because of the employer, because of some other restrictions, because of some reasons, okay? So there is a time frame in the 2017 Rainbow Suite in the FIDIC. You have 21 days for revised program, you have 14 days. If you are not responding, Mr. Engineer, it is deemed no objection. So there are a lot of time frames, new time frames in the latest schools, as I gave FIDIC as an example. Yeah.
Tony, if I want to just to jump in there, I think going back a couple of steps, I think the avoidance issue has to stem from an appetite for it. I think both parties, I think, Amar, you touched upon this issue as well, that both parties have got to want that. It has to be a mindset from the beginning of the project that both parties are going to try wherever possible to avoid disputes. So I think even before we start looking at contract clauses, what have you, I think there needs to be an appetite for it, and there needs to be a mindset to say we're going to try to avoid disputes wherever we can.
Yes. And Nabil, do you come across circumstances in which it's actually very difficult to get parties to engage in appropriate dispute avoidance? techniques?
Yeah, I mean, I think at times it also comes down to jurisdictions where you work. Dispute avoidance requires a buy-in. There's got to be a flexibility from both parties to be able to make decisions that are possibly going to affect time and cost. Avoidance of those can be tough. You may well get jurisdictions or employers or engineers or people within the employer's personnel that don't want to make those kind of decisions. You may have the best intentions to try go into a contract and say, I want to try and avoid disputes. But there might be a situation where a decision needs to be made and certain members of your opposite number are not willing to make those decisions for whatever reason there is. So there are barriers and hurdles. But I think the biggest thing to try to get over those is possibly education, to try to see that if by making the decisions you make now, you would avoid the problems later. But of course, those are at times people don't want to be that kind of decision maker, or I'm not going to agree to a certain thing in case someone asks me later why. That thing. So there are some hurdles and barriers, obviously.
And in those circumstances, you can write all the provisions you want into a contract, and it's not going to help. In fact, it's just going to delay the ultimate resolution of a dispute. So perhaps that's one of the downsides.
Yeah, that's one of the downsides. Yeah.
So look, over I guess the last couple of decades, we've seen an explosion in dispute avoidance techniques and various mechanisms and procedures, and in fact, these days it's very common to see them, layered in multiple textures and flavors into the same contract, and that's very much the FIDIC approach. Amma, do you want to just talk us through the different possible mechanisms that are available for dispute avoidance?
We have the amicable settlement in FIDIC. Also, we have the mediation. I really do encourage to participate in the mediation every single time. Okay. Even we have the ICC mediation and arbitration. The mediation is before the arbitration. We have the rules 2017 plus the amended rules 2021, which has been issued recently. Okay. So they amended in a positive way the ICC. Also, they amended the expedited arbitration as well. Okay, so there is an arbitration which can be done within 6 months, up to $3 million US dollar in the ICC arbitration. So back to the mediation. Either in the FIDIC forms of contract, they kept the amicable settlement, which is in the same concept, but they reduced the duration from 56 days to 28 days. But there are two concepts in the form of contracts, FIDIC or other form of contracts. There is a concept called agree or determine. So either you can agree or determine. Plus there is a concept which is condition precedent called due consultation. It is an obligation on the engineer to do due consultation before issuing the determination. Otherwise, the engineer will be in material breach.
Thank you, Anna. Nabil, do you want to talk a little bit about what you think are the most effective forms of dispute avoidance?
I mean, certainly in the last few years, that word avoidance has been like the latest buzzword in the industry. It's like avoidance. Everyone's trying to do that, and I think that the tools by which parties can attempt to avoid disputes are, like Amir said, there are plenty of them. I think we'll come on to this issue of the dispute boards, and I think that's probably one of the ones that people think of most when you talk about avoidance. The ability of the DAAB in the FIDIC conditions to be that sort of first point of avoidance. Having mentioned the DAAB, they're only as good as you want them to be. If you give the DAB the power to be inquisitorial and ask questions and be able to find little areas where it feels that both parties need to come together, then you have the benefit of the real avoidance issue. The mediation, again, as Emma mentioned, that is also a method. However, that's not contractually tied into many standard forms of contract. At times, there is some clauses that say one needs to go to mediation before they go to arbitration. Mediation, again, it doesn't avoid the dispute because the dispute is still crystallized there. I think we have to keep in mind that dispute avoidance is the issue of trying to avoid getting to the point where you have that kind of disagreement. It's trying to amicably settle the issues you have without a formal sort of request from someone else to intervene. So I think that the DAAB is your sort of first point of reference, whereby they do try to give their parties that sort of recommendation or even some kind of a decision of some sort, but to not get to the point where it's going to be a contentious issue.
And of course, there are a whole bunch of procedures which can be used either as avoidance or as resolution, things like escalation to chief executives or whatever it may be,
exactly.
early neutral evaluations, or all the rest of it can be used pretty much at any stage of the process.
And those are quite useful. You see multi-tiered levels. So you'll have a situation where if a claim is reached a point where parties don't agree, then possibly there is a discussion at a senior level of the two different parties. Can they resolve it? It's more, as Amir said, in certain contracts called amicable settlement. So there's a period of time by which people try and get together and say, okay, can we see some differences? Can we put away our differences and see whether we can agree? And what does happen there is that you get people involved who are not part of the day-to-day runnings of the project. So they're not tainted by prejudices where that can be a problem. So you sometimes get senior members of the contractor or the senior members of the employer who aren't part of the day-to-day runnings, and they sit down and say, right, what is the real issue here? Can we resolve this? And often it's not a contractual decision, it's more of a commercial decision that, okay, we can live with this, and we'll sell it to our respective parties. So there is that ability as well.
I've often felt that there's a real advantage to an early escalation provision, even if they're not able to sort it out at that point. They've started talking. These are the people who ultimately will decide to settle the dispute in a year's time, in 2 years' time, whenever it may be. And if they've already started that conversation and really focused on the matter, that can only help.
What sometimes happens is that the site management or personnel can at times be at odds with the management, because they've got a sort of slightly different agenda. They feel that, why are you negotiating away a position that is relatively strong for us? So there is that sort of fight sometimes internally. Do I want to avoid this dispute, or do I want to take this to the next level? So there is that problem as well.
Good. So let's move on to dispute resolution, having put avoidance behind us, thankfully. And obviously most stakeholders to commercial contracts will be intimately familiar with arbitration and litigation. And before looking at the alternatives, it's probably worth spending a moment just to touch on the perceived problems with those modes of dispute resolution. So Nabil, have stakeholders fallen out of love with litigation and arbitration? If so, why?
Were they ever in love with attorney? I mean, I think, as we mentioned earlier this morning and earlier today, that arbitration litigation is a very expensive process. It's time-consuming. It takes people away from their day-to-day business and sets them into a situation where they've got to try and remember something that happened 3 years ago I can't remember what I had for dinner yesterday, let alone what I did 3 years ago on site. Records are pretty sketchy at times. It's a difficult scenario in that respect. It's driven mainly by cost. I don't have statistics at the palm of my fingertips, but I can with all certainty say that arbitration is a terribly expensive process.
Reassuringly expensive, some of us might say.
If we can, in some way, not get into that scenario, then all the better. So I wouldn't say, as people fall in love with arbitration. Arbitration is the ultimate dispute resolution. It is the benchmark for the construction industry, international arbitration. But I think that there is this conception that it is very expensive. Some of the costs are not even very obvious. You'll tie up people who are going to be generating income into an exercise that potentially could generate some turnover, but it's not necessarily a guarantee. Then again, I hear people say that neither is a construction project. I mean, you can run into difficulties. However, if you ask contractors generally and engineers and people who are on site, they'd rather be working and building something than fighting over what happened about 4 or 5 years ago. Tony would disagree, but I'll hand it.
So, is there anything that can be done to salvage arbitration, which ultimately is likely to be the ultimate method of dispute resolution under most of the contracts to which we're party? Is there anything we can do to make it a better process for the players? Amir, do you want to speak to that?
Actually, we have an experience in this regard. Like in Saudi Arabia, we have virtual arbitration now for small cases, something like lesser than 200K. We have virtual arbitration. The problem, Tony, is that the arbitration is taking nowadays in MENA region on some countries something like 4 or 5 years. And it's really expensive. And some of the arbitrators on purpose, they are like making the case to be longer and longer, so they take more fees, some of them. I experienced this in Jordan in some arbitration, which were something like $100 million. And finally, after 4 years of hearing sessions, matter hasn't been resolved. Like, come on. So there is an intention in MENA region for smaller projects to go for litigation drafting in the contract, in the clauses itself. Some of the clients insisting to have arbitration clause actually depend on the arbitration rules in the country, like Qatari arbitration law, Saudi arbitration, Jordan arbitration law. So this is the case. Again, in the FIDEC forms of contract, we have ICC arbitration rules, which has been amended, as I said, in 2021. Okay, and again, they kept the expedited arbitration, which I love it. Okay, there is a dispute, which I am part of it, and we proceeded with ICC expedited arbitration. When the client saw that, or let me say the other party saw that, and so that we are serious, and unfortunately, before the arbitration, we have to go. It's fortunate that we have to go for mediation, but the process was very lengthy, something like 84 days for mediation before I can go to arbitration. Then I sent a question to ICC, written question. Can I go for arbitration immediately without, this is my contract, without going to mediation? They said, no. You cannot. So, okay, let me read the contract. I'm telling you practical case. Let me read my contract. Then I found out that, mediation, I have to appoint a mediator from FIDEC itself. Why do I have to do that? From FIDEC itself. So, if you send the email to FIDEC, it will take a long time to respond, to appoint. It's long procedure. So anyway, I resolved it amicably with the client because of all this rubbish drafting of dispute resolution clause in the contract. See, on other contract, Tony, I have 4 general conditions of contract at the same contract. Imagine. So in every general condition of contracts, We have dispute resolution clause, but it's different than the other. One is FIDIC, one is bespoke. It's a big contract. Okay. See, when you are appointing a contracts manager or a lawyer to draft your contract, please don't go to the cheap ones. Okay. So don't go for one who is taking $1,000 or yeah. I mean he should be competent. The other thing. You have, as my colleague said, well said, Nabil, that we have to avoid the dispute before we are in a dispute, before the spark of a dispute. We have to avoid it. How? Like, I'm not, I like the 2017 suite of FedEx contracts, but I'm not happy with all clauses drafting, okay? So I'll take the fruit from in there. If my client is telling me do this, this type of contract, I take the fruit not only from FedEx, wherever good experience, and I put it in the particular condition of contract. Like what I said, the 4 examples, the time frame, okay? So the engineer is not a holy entity, okay? You have your duty, you have your obligation, please do it timely, otherwise the project will be in trouble. Don't prolong your approval or, sorry, your consent or no objection on the program for 4 months unnecessarily. If there is something, fine, but don't prolong it. You are doing the disputes, Mr. Engineer, while you should be the avoidance. Also, emphasizing of what Nabil said. Now, the DAB, we have avoidance, DAAB, okay? So their job to have standing DAB, avoidance of dispute before the spark is in place. Okay, FedEx kept a small window in the guidance of 2017 Rainbow Suite for ad hoc cases. Okay, so still you can go for ad hoc in the particular condition. Last thing, I just wanna say something regarding the DAB decision. We can have a good faith. Do not consume the 84 days, please. I'm telling you from my experience. You have 84 days to issue the decision, right? Do not consume it all if you can. If you can. If you have standing DAB, okay? You are every day here, Tony. So you know everything. Come on. If you can issue the decision, it is simple piece and you got a referral from parties. Come on, you can issue it within a week time or a month time, okay? It is written the contract within. It's not a holy or mandatory to consume it. So I was telling my colleagues, if we have a notice of claim issued today or issued 1st June, okay, then 42 days, assume I consumed the 28 days barring before getting barring for the claim, then 42 days, it's in parallel actually, it's not after that, then 42 days for the engineer to review the claim, then determination has been issued after 42 days, then okay, there is a dispute, and I calculated the durations and I found still, despite that the new Rainbow Suite of the FedEx reduced the amicable settlement from 56 days to 28 days, it's very long procedure. So I'm amending that as a particular condition.
So thank you. And I think Ahmed, that sort of nicely illustrates some of the downsides of these very elaborate tiered dispute resolution provisions. And for better or for worse, the FedEx suite probably has the most sophisticated and elaborate set of dispute avoidance and dispute resolution procedures. And you've talked about some of the features of that, Anna. One of the innovations of FIDIC really has been the DAB and then more recently the DAAB. One of the functions of the DAB in its adjudicative role has been to render decisions which are binding but not necessarily final. If a notice of dissatisfaction is served in the relevant period. Now, I mean, historically, there have been problems with enforcement of DAB decisions, and we all know the Passero line of cases, and the difficulty, the lacuna there was in the drafting of the old FIDIC forms. That's been addressed. But I'm interested to hear the panel and actually the audience's experience of DAB decisions under the new forms. Are they being enforced? Are they being complied with? And if not, why not?
Just a couple of just steps back, if I may, very quickly. As Amir mentioned, many disputes arise from the actual arbitration clauses themselves. Poorly drafted clauses. You're arguing for months, if not years, on the actual dispute clause itself before you even get to the dispute itself. So that's a real big issue. The enforceability, or just the getting or the receiving of an award, sometimes is the kind of the first step. The real advantage of a DAAB is the quality of the panel and the board itself. If that board is able to gain the confidence of both parties, then you have a better chance of getting those awards accepted in a way. Of course, there is the notice of dissatisfactions, etc., etc. Strabag's had good experience with panels that are put together in a way in which both parties are happy. That panel or those panels then gain the confidence of the parties, and the parties understand that decisions that are made by those panels are binding upon them. And more often than not, you do see payments being made. On the slightly larger ones, I mean, if you get tens of millions of dollars or euros or pounds when the DAB or DAAB is making decisions on, those are a little bit more tricky. But more often than not, if the DAAB panel is trustworthy, has gained a reputation for being straightforward and reputable, then there is a better possibility that those awards are followed up with and settled, and you move on. Because you always remember that it's not the final. There is an arbitration that you can instigate if you're not happy. And if that is an arbitration, then that arbitration should basically be on the enforcement of the decision rather than reopening the whole term again. So I think depending on the panels, you do see that they do work.
I'm interested in the audience's experience with this. I mean, my sense is that adjudication in the UK has completely transformed construction dispute resolution. We see far fewer substantive disputes going through to either litigation or arbitration than we did back when I started too many years ago. And the DAB under the physic contract ought to have the same effect. It's an interim binding decision that parties are obliged to give effect to. But my sense is that it doesn't, either because parties don't comply or because there are difficulties with enforcement or whatever. So perhaps we could try a old-fashioned way, a show of hands. Who has had DAB decisions? Let's start with enforced. Okay, well that is pretty telling.
Yeah, that is another
now, of course, it may be that simply because you don't need to have them enforced, because people just comply with them, because enforcement is straightforward. So let's have a show of hands. Who has had DAB decisions complied with? 1, 2. It's not great, is it? Clearly hasn't quite had the effect that those of us who have watched the adjudication have effect in the UK might have expected. So dispute resolution, dispute avoidance provisions in contracts, standard form contracts, I think are probably more heavily amended than any other part of the contracts. Certainly my experience of FIDIC contracts that they tend to be very heavily rewritten. Nabil, what's your experience of this? What amendments do you see, and what are the drivers for those?
Yeah, and as you mentioned, sadly and unfortunately, the DAAB or the DAB provisions within the contracts are more often than not in certain jurisdictions just cut out. That's detrimental to the whole way in which that contract is drafted. Certainly in from the 1999 FIDIC contracts onwards, there is this principle of a dispute adjudication or avoidance board. The whole contract is predicated on that issue. Not having it suddenly redresses the balance of the whole contract. If you just simply strike it out, you then have a contract that is almost lopsided. It doesn't work. When you now take it into 2017, where the DAAB now has the power, if you give it to them, of avoidance, such a massive function is then just removed. Not only is the function removed just so that you don't have a DAB, but we were discussing earlier this morning and at lunchtime with Sebastian, who was also part of the drafting committees. You need to go through that contract and remove the DAB principle, not just in words, but in its essence. And by removing that, you really do render those contracts in a way, I wouldn't say unworkable, but they become really difficult to manage. So I think, sadly, that's one of the things you do see that are knocked out, and that's something that you see maybe more in certain jurisdictions than others. I think Amr will probably elaborate on that a bit.
Amr, do you have anything to add to that?
Yeah, I have a practical case, which is a Yellow Book 2017 Rainbow Suite, in which the client removes the DAB totally. And as you are aware, the DAB is in every single, not every single page, in every single line in the suite itself. So come on, like, this is not only a breach of golden principle, it's not, the FIDIC is saying is not a FIDIC anymore. Back to the concept. Do we have a benefit of having a DAB, a standing DAB? Yes. There is avoidance before the spark of the dispute, okay? So on daily basis, there is someone is sitting like three of the DAB, and if I am the decision maker, I will not put three of them as an engineers. I'm not talking about the contractual engineer. I may put, like arbitration, what we are doing, I really recommend to have a lawyer and one engineer, and the chairman will be whatever, okay? One more thing, if you allow me, Tony, I'm touching the resolution itself after I'm saying something about the DAB, the enforcement of the DAB. In MENA region, what I noticed after working in 4 countries, in GCC countries plus Jordan, they are not a fan of DAB. I was trying to convince them, many clients, about the DAB. What are the benefits of the DAB? It's not a breakup between the relationship between the parties. Come on, it's not arbitration. It's not litigation that we are sitting in the court and match is over, okay? So I could not convince them. So enforcement about the DAB, if the decision is issued today we are 5 July, like 6 July, and we have 28 days for either party to issue NOD, which is notice of dissatisfaction. Okay, so it is binding from the day of the decision. If there is no NOD from either party, it is final and binding. It's final and binding. It's over. Okay? So what if, you are hearing me, right? Okay. So what if Nabil is party and he is unhappy about my decision as a DAB? So he doesn't want to issue an NOD. Meanwhile, he is not following the decision. So what we can do, we have to go for arbitration to enforce the DAB decision. Yeah, so we have to go for arbitration to enforce that decision. Again, to the resolution matter after dispute avoidance. See, we have to have some open-minded. When I'm sitting on a table with you, okay? If I'm the engineer or if I am a party, okay? So we have to understand a lot of things. I have to understand I'm talking to who. I have to have my red lines. Like if you have a claim with $1 million, you shouldn't come to the meeting and say if there is $1 less, I'm out of this. You have to discuss with the owners, with your management before you come to that meeting, and you have to have red lines. And it is finally win-win situation. You won't win everything in any dispute. Tony will correct me from his long experience of disputes, okay? So you have to let parties feel, if you are the engineer, that you are really neutral. It was impartial in FIDIC 87, then fair, then they corrected to neutral, okay? Because we are not fair people. We are just taking the contract and implementing the contract.
Yeah. Thank you. So look, my experience is that the DAB provisions are very commonly struck out, and particularly in, I think, almost all the work I've done across the Middle East, you almost never see DAB provisions. And I agree, it fundamentally changes the risks in the contract. It essentially means that owners can hold contractors to ransom. It means that they can drip feed enough money to get the project done, extract settlement agreements out of them for claims at an undervalue. And so for me, when I'm advising clients, I can't say it's a red line, because if you don't agree to it, you don't get a look in on the projects. But at least it's something that I think contractors should price for. If there's no DAB provision in there, there's no opportunity to get cash flow on a fair basis during the currency of the project. That is a real risk, and it's something that contractors have got to take into account.
I think the other issue is that when you have a dispute, more often than not, the decision-making party doesn't want to make that decision for whatever reason it is. If you've got an engineer who's suddenly faced with a £50 million claim, and it awards 45 million and a year's extension to the contractor, the employer's going to look at the engineer and think, okay, I employ you, and what are you doing here? Whether it's right or wrong, there is that human nature element. The DAAB almost takes that away, and it gives the ability for an engineer or an employer to turn around to an employer and say, it's not me that has decided this. It's a third party. And remember that panel that you put together, you have a choice on that. So you put forward somebody, the other person puts forward somebody, and you choose someone who's going to be your chairperson. The quality of that panel is really important. As I keep mentioning, that the better your panel is, the more chance you have of getting a reasoned award. That doesn't take away the issue that it's going to be struck out. But I think an argument to say keep it in would be to say it takes away that responsibility from a member of the construction team that maybe doesn't want that responsibility, and then there is probably a better chance of the project being successful if you keep it in.
I think that's a very important point. I think we're pretty much at the end of our time, so we'll wind up there, subject to any questions that we might, or observations that we might have from the floor. I've had a couple of interesting questions in. My favorite is, have you come across an arbitration-loving client that gets higher utility from arbitration than from avoidance? I haven't yet, but I'm looking out for them. Are there any other questions, observations before we wind up and hand over the final session? No. All right. Well, look, thank you very much indeed. Thank you.